Thank you, Presiding Officer. The Cabinet Secretary said in the debate in this place in December, the status quo is not tenable. We have to make changes, and therefore it's important that we set the tone by showing, as we have done today, that's December, that this is about having a discussion and debate with the legal profession and the general public. And I think today's debate, wide-ranging as it is, has maintained a proper tone to help us all be better informed as we move to further discussions on this. I very much welcome the opportunity to return to Justice debates. I served in Session 1 on the Justice 2 Committee and in Session 2 on the Justice 1 Committee. With a major prison in my own constituency, I've taken a close interest in the penal system, visiting prisons in Peterhead, Porterfield, Saughton, Polmont Young Offenders, La Bapaume near Paris, Park Prison in Wales. I've visited sheriff courts at Dornoch and Glasgow, and I've served on a jury 30 years ago at Linlithgow Sheriff Court, and indeed I visited Carstairs on one occasion, the Hospital for the Criminally Insane. None of that makes me an expert. I'm surrounded by a lawyer, a policeman, a QC and another lawyer, all who have spoken in the debate and have expertise to which I'm not even going to try and aspire. I'm merely, as Rumpel of the Bailey might have said, an old Bailey hack. I'm an old Parliament hack in matters like this. We do know that justice operates very differently in other countries. In 2006, when I was across on 2 occasions in Georgia in the Caucasus, under the sponsorship of the Westminster Foundation for Democracy, running courses for local political parties and how democracy worked, I had the opportunity to meet the Georgian Justice Minister. And his great claim to fame was he'd put 3,000 more people in prison and reduced the time it took to be in the queue to get into the prison to visit your relatives down from a week to 3 days. A very different environment from the one which faces us today. I think I might start by saying that it is obvious that not every customer of the system is entirely satisfied, and I say that both from the point of view of the victims and, of course, those who are being prosecuted. Indeed, in coming down to Parliament yesterday on the train, in the seat behind me, I had an animated conversation between someone who is clearly a criminal. He's just broken the terms of his parole and he thinks he's going down for 4 years. His chum trumped him. He said he's up on an attempted murder out on bail. I didn't attempt to engage them to get more details. I thought that might not be the thing to do. On another occasion, I was in a cell in Saughton as a day visitor with six murderers hearing their stories. And one of them was complaining to me that just because he'd been released on still in his life sentence, he'd been released, he'd been recalled simply because he'd been present at another murder. So he hadn't committed it, he'd only been present, and that really shouldn't have counted. So therefore, some of the things that we hear about the criminal justice system and its operation are things we probably are going to discount significantly. But we shouldn't imagine that we have a perfect system. It is necessary that we look at the system. It is necessary that we seek ways of improving it. Several contributors to the debate have touched on ways of allowing people to appear in court, to appear before a sheriff without necessarily being physically present, using television, using other ways of getting to court. And I think that's absolutely the case. Many of the processes that we have are very much by rote and don't obviously contribute to justice. When in the Justice 1 Committee we visited Glasgow Sheriff Court on a Monday morning, we were in the court for an hour, sitting in the jury box, which was not being used, and we saw 59 appearances being dealt with in a single hour. And we were left pretty baffled as to how any of this contributed to justice. So I think ways in which we can avoid having to aggregate lots of people in one location using modern technology is something we certainly should look at. Now, on my appearance as a juror in Linlithgow Sheriff Court some 30 years ago, listening to the issue around corroboration, the discussion of evidence that we've had today, it does strike me that now evidence is a much more complex and diverse issue than it was, say, 100, 150 years ago. One of the things that happens, of course, and I found in the two-day trial I was on a jury, that the sheriff was absolutely first class in his summing up and explaining what was expected of the jury, showing the tests that we might apply to evidence in considering whether the guilt or innocence of the two accused who were in front of us, what verdicts we should come to. But I can't help imagining that really, with the increased complexity, the sheriff might usefully have told us before we heard the evidence the sort of tests we might have been thinking about as we heard the evidence. When it's a two-day trial, you can think back. I had a professional colleague who was once on a trial that lasted 4 months, trying to remember what happened 3 months ago. Well, I can't remember what happened last week most of the time, and I know that I'm not alone with some of those of us who are of an age. Now, on corroboration, and I will bring my remarks to a conclusion as soon as you nod more vigorously, Presiding Officer.
1 minute.
I think, thank you very much, that's helpful. 150 years ago, we were looking very much at remembered evidence. The evidence of what people saw was reported to the court. Now, very often, we're looking at evidence that is recorded evidence. Technology has provided the evidence. The character of it is quite different, and the way we should judge it is quite different. It's 110 years since the first person was a victim in the criminal justice system of the benefits of dactyloscopy, in other words, the science of fingerprint recognition. From that point onwards, science became part of the evidence base. We may not yet have fully caught up with everything that came on. Michael McMahon, I very much am interested in his efforts on the 3 verdicts, but let's abolish not guilty and keep not proven, because it's the older verdict. Incidentally, in my Sheriff Court appearance, of the 14 charges there were, we had 7 not provens, 5 not guilties and 2 guilties. So juries are quite capable of dealing with it when they have the evidence. Presiding Officer.